Okay.
My appearance for the defendants.
Yes, this matter is for ruling.
Hello.
I said this. Yes.
But I would like to crave the indulgence of the court to allow, we have some law school experts to monitor, to observe the proceedings. I just crave the indulgence to allow them to be.
It's okay.
Here.
It's
Thank you
all
very
right.
much.
Yes. This matter is for ruling. The ruling of the court goes like this. This is a notice of preliminary objection dated 24th day of November 2022 and filed on the 25th day of November 2022. The notice of preliminary objection was brought pursuant to Order 17, Rules 1 and 9, Order 30, Rules 18, Sub-Rule 1 of the National Industrial Code Civil Procedure Rules 2017, and under the inherent jurisdiction of the court. The dependent applicant is by this application or this preliminary objection praying this court for an order dismissing this suit for being an abuse of process, having been commenced by the claimant respondent during the pendency of suit number NICN/UY/41/2018, Godwin in them and 41 others versus Mobile Producing Nigeria Unlimited, and suit number NICN/UY/06/2019, Anidium ECFO versus and 77 others versus Mobile Producing Unlimited. The grounds for the objection are as follows. I will skip reading the grounds, so counsel will read them when they collect the hard copy. The notice of preliminary objection is supported by an affidavit sworn to by one Ayo Elasami, a litigation executive in the law firm of Bango and Egodalo, representing the defendant in this suit. The crux of the fact deposed to in the affidavit in support is to the effect that the claimant respondent instituted the present suit on 17th day of November 2020 via a general form of complaint, statement of facts, and accompanying processes, seeking orders of this honorable court, enforcing the judgment of the Supreme Court delivered on the 20th day of April 2018 in case of Mobile Producing Nigeria Unlimited versus Okon Johnson and others, appeal number SC/33/2010. V, directing the applicant to pay respondent the sum of 24,120,618,90 naira 65 kobo in satisfaction of the alleged unpaid salary alias of severance benefit packages due to the respondent from applicant, in line with the collective bargaining agreement between the applicant and its employers. It was also stated that the claimant respondent herein are claimants in similar action previously instituted against the dependent applicant, wherein they seek to impose the Supreme Court judgment and their purported entitlement for alleged unpaid salaries, allowances, severance benefit packages, and pension due to them from the defendant applicant. The aforesaid actions, which are still pending before this honorable court, are constituted in suit number NICN/UY/41/2018, Godwin Indem and 41 others versus Mobile Producing Nigeria Unlimited, suit number NICN/UY/06/2019, Anidon, Ekfo, and 77 others versus Mobile Producing Nigeria Unlimited, and suit number NICN/UY/13/2019, Lawrence Wakama and 90 others versus Mobile Producing Nigeria Unlimited. Copies of the amended general form of complaint and amended statement of facts in the previous cases were attached to the affidavit in support, and they were marked as Exhibit MPN1 to 1 MPN3. The relief sought in the previous suits are similar to the same with the reliefs endorsed on the originating processes commencing this suit. The aforementioned reliefs were sought in respect of the judgment of the Supreme Court regarding unpaid salaries, allowances, severance, benefit, and pensions. The subject matter of the previous are the same with the subject matter in the present case. A written address was filed along with the notice of preliminary objection, wherein a single issue was formulated for determination, to wit whether this suit is not liable to be dismissed for being an abuse of process. In oral adumberation before the court, Adeta Talabi Esquire, counsel for the defendant applicant, informed the court that he is relying on the affidavit in support and the written address. He is adopting the written address as his argument in this case. Counsel also relied on the further affidavit and the reply on point of law. In arguing the sole issue for determination, counsel started with the meaning of what constitutes abuse of court processes. I relied on the case of Chief Shodifo Lamikane and another Shodifo versus Lamikane and another case of Ume versus Iwu, and that of Expo Limited versus Pafab Enterprises Limited. It is the submission of counsel that the courts have laid down certain principles certain principles and guidelines in demonstrating what constitutes abuse of court processes under our civil procedure. And such circumstances include: one, instituting multiplicity of action on the same subject matter against the same opponent on the same issue, instituting a multiplicity of action on the same matters between the same parties. B, instituting different action between the same parties simultaneously in different courts, the grounds being different notwithstanding. C, where two similar processes are used in respect of exercise of the same right. D, where there is no law supporting a court processes, or where it is premised on frivolity or recklessness. E, where a party has adopted the system of foreign shopping in the enforcement of conceived right. F, where two actions are commenced, the second asking for relief which may have been obtained in the past. The second action is prima facie vexatious and abuse of court of process. G, where a party litigant litigates again on the same issue which has already been litigated upon. H, where a party duplicates a court process, the more current one which resulted in duplication is regarded as an abuse of court processes. I, where two actions of similar or same nature and between same parties and subject matters are being prosecuted concurrently before the court or in different court. It is the latter in time that vacates Council further refers to the cases of Ukachukwu versus Uba, UBN versus Edamukwe, Abubakar versus BO and AP Limited, Jimo versus Tako Nigeria Limited, African Continental Bank PLC versus Damien Ikechukwu Nwagu, African Renaissance Corporation and JDP Construction Nigeria Limited, and R Banke Nigeria Limited versus Cadbury Nigeria PLC. It is also the submissions of counsel that where a party improperly used judicial process to impede or interfere with the due administration of justice, same amount to abuse of court processes. Thus, the multiplicity of action on the same subject matter or instituting same action at different forums against same opponent, even where the right to bring an action exists, amount and abuse of process. Reliance was placed on the case of Saraki versus Kotoye regarding these principles. In continuation of his submission, counsel submitted under the extant legal jurisprudence in Nigeria, the court are empowered to prevent improper use of its machinery or processes to harass, oppress, vex, or irritate an adverse party in litigation. By the provision of Section 6 of Section 6A of the Constitution, this court has the power to prevent such conduct of instituting or continuation of any proceeding which are manifestly vexatious or scandalous. To buttress the point being made, counsel refers to the case of Prince Einde Ojo and 3 others, Olayiwola, Olawore, and others. He also relied on Jesiah Cornelius Limited, and others versus Chief Cornelius Okeke Ezewa. He also relied on J.O. Amao and another versus Attorney General, North Central State, and others. He also relied on Baswani Trading Company versus Sabalak and Company. On the rationale for the foregoing proposition of law, counsel refers to the case of PDP versus Chief Anayoroches Okorocha, Alhaji Muhammadu Maigari Dingyati, and another versus INEC. According to counsel, the claimants respondent having presented their grievances on the alleged unpaid salaries, allowances, severance, benefit, pension before this honorable court in the previous suit, they cannot further ventilate the same grievances in the present suit. Counsel submitted that the present suit before this honorable court in relation to the defendant applicant is aimed at irritating, annoying, or scandalizing the dependent applicant without moral. It is also an attempt at gold digging aimed at exploiting the applicant. Counsel also refers to the ingredient of abuse of processes as adumbrated in the case of Ume versus Iwu. Counsel also refers to the definition of multiplicity of suit in Black's Law Dictionary and further refers to Ume versus Iwu Sufra. He also refers to the dictum of Nikitobi JSC of blessed memory in the case of Agwasim versus Ochi and another. Counsel also reproduced the reliefs being sought in the case in NICN/UI 41/2018, Godwin in them and 41 others versus Mobile Producing. So I will not read those ones. Counsel will read them when they collect the hard copy. He also reproduced the reliefs being claimed in the present suit. Counsel submitted that except for the monetary claim, all the other reliefs are the same in the present case and in the case of Anidion ECFO versus Mobile Producing Unlimited. Therefore, and the parties are as well the same in both suits. counsel submitted a cursory look at the reliefs sought between the respondent by the respondent in the previous suit and in the present suit. They are the same. They all point one thing, that is pointed to the same subject matter, that is unpaid salaries, allowances, severance, benefit, and pension. On the suit being on the same parties, counsel refers to exhibit MP1 to MP4 and submitted that a comparison of the parties will show that the parties are the same in the suit, in the current suit, and also in the previous suit. Based on this finding, counsel asked the court to hold that the applicant has satisfied the ingredients for holding that this case is an abuse of judicial process. Counsel asked the court to so hold and dismiss this action for being abuse of court process, as it is the proper order to be made as per the decision in the case of Uniform Industries Limited versus Oceanic Bank International, Africa Renaissance versus JDP, and host of other cases cited by counsel. In concluding his submission, counsel submitted that the claimants have been able, the defendants, applicants have been able to show that this suit as it is presently constituted before the court is an abuse of process and liable to be dismissed. Counsel urged the court to dismiss the suit. In opposition to the notice of preliminary objection, the claimant's respondents rule forth claimant defers to a 13 paragraphs affidavit wherein it was stated that the claimant on 16th day of August 2021 filed a preliminary objection on the ground that this matter is res judicata. After hearing argument, the court ruled in favor of the claimant and ordered amendment of the originating process. The claimant complied and the matter was adjourned for hearing. The present preliminary objection is employed to continue to thwart the speedy hearing of this matter, that it is not that this matter was filed during pendency of this suit number NIACN/UY/41/2018 between Indem and others versus Mobile Producing and that of Anidion. According to counsel, this matter was first filed in your Judicial Division, which with several plaintiffs as claimants, that due to the several issues and accusation and counter accusation in the matter, the presiding judge in Uyo Judicial Division caused the matter to be transferred to Calabar Judicial Division, where they are presently where it is in the presently. In the written address filed in opposition, counsel for the claimant adopted the issue formulated by the counsel for the defendant. In answer to the issues formulated, the counsel for the claimant submitted that this matter is not an abuse of court process and not liable to be dismissed as submitted by the defendant. Conversely, if there is any document to be dismissed being an abuse, it is an instant preliminary objection of the defendant. The issue has been raised before this court, and this court delivered a considered ruling in favor of the claimants and adjourned this matter for hearing. When the matter was set for hearing, the defendant brought this motion again. It is the submission of counsel that several authorities cited by the counsel for the defendant are not on all posts with the case at hand. They are distinguishable. And counsel contended that it is not the position of the law that where a matter is moved or transferred from one division to another, The latter is an abuse of court process. The defendant has taken several steps, filed defense and motions. This application is in bad faith with the sole purpose of frustrating the speedy hearing of this suit. This suit was filed 2 years ago and hearing is yet to start due to several objections of the defendant that are obviously baseless, cosmetics, and trivial. Counsel rely on the case of Idigbe and Adelaju on the exploitation of Justice Agim JSC, which frown at this kind of situation. Counsel asked the court to dismiss the application with 200,000 naira quote. The defendant, in reaction to the counter affidavit and the written address, filed a 7-paragraph counter affidavit and a reply on point of law. Counsel for the claimants, Mr. Mbe, in arguing this in oral adumberation before the court, relied on the deposition in the counter affidavit and also adopted the submissions made in the written address as his argument in opposition to this application. Counsel also submitted that contrary to the submission of counsel for the claimants, counsel submitted that the present case and the previous cases are not on the same issues, reliefs, and subject matter. Counsel asked the court to dismiss the defendant's application and grant and ordered accelerated hearing. Counsel for the defendant applicant also filed a reply on points of law and a further and better affidavit. The submission of counsel in that respect have been captured, so counsel will read those submissions when they collect the hard copy. I now go to the decision of the court. I have carefully and painstakingly perused the processes filed in this suit, as well as the processes filed in suit numbers NICN/UI/41/2018, Godwin Indem and 41 others versus Mobile Producing Nigeria Unlimited, suit number NICN/UI/06/2019, Anidion Echo and 77 others versus Mobile Producing Unlimited, and suit number NICNUY/13/2019, Lawrence Wakama and others versus Mobile Producing Nigeria Unlimited. I have equally considered the written and oral submissions of counsel in advancing the positions of their respective clients from the prayers contained in the notice of preliminary objection filed by the defendant applicant. The objection of the defendant applicant centers on abuse of court process. The positions of the defendant applicant in this case is that this case as it is presently constitute an abuse of process of court, because to the defendant there are suits pending before this court when this particular present suit was filed before this court, and the claimants in this case are also claimant in the suit pending before the filing of this suit, and the subject matter in the present case and the cases already pending are same. The claimants on their part are of the view that the present action as it is presently constituted is not covered by the doctrine of abuse of court process, as according to the claimant, this case is a continuation of suits filed at judicial divisions of the court, which were transferred to Calabar division. The claimants are also of the view that The notice of preliminary objection is employed to delay further hearing of this case. They are also of the view that this court has dealt with the issue being raised by the defendant in this case, in this application, and the court has ruled in favor of the claimant. Therefore, this application must be dismissed. I shall at this juncture consider whether the issue of abuse of court processes has been dealt with by this court, because if that has been the situation, this court will lack the bias to continue to consider the objection, as it will amount to sitting on appeal against its own decision, which is not allowed in law. Furthermore, if the issue had been dealt with, this court would be functus officios to further consider the issue. By the notice of preliminary objection dated 16th day of August 2021, the defendant applicant pressed this court to dismiss the claimant's respondent action on ground of res judicata. On 23rd day of February 2022, counsel argued the preliminary objection, and on the 12th day of May 2022, this court rendered its ruling, where the court found that some of the monetary claims of the claimant have been dealt with, have been caught by the doctrine of res judicata. The court ordered the claimants to amend their originating processes commencing the suit filed on the 17th day of November 2020 to be amended to be in line with the order of the court. The monetary claim of the claimants affected by the order of the court in the initial case was affirmed by the Supreme Court on 20th day of April 2018 in Mobile Producing Nigeria Unlimited and Okon Johnson and others. The decision to which the claimant claim are based is present action. It is my view that the ruling of this court rendered on 12th day of May 2022 in respect of objection raised by the defendant applicant was on res judicata and not on abuse of process of court. Even if the ruling of the court dealt with abuse of court processes, it will have no effect on the current objection under consideration, because the ruling of 12th day of May 2022 was based on the case of claimants that started from the Federal High Court Uyo, the garnishing proceeding initiated at the Federal High Court Uyo, and the appeals dealt with by the Court of Appeal, the Supreme Court, and the Supreme Court. In the circumstances, I came to the conclusion that the issue of abuse of court processes being raised in the current objection has not been dealt with by the court in the previous cases. The claimant in this has not been dealt with by this court in the ruling of 12th day of May 2022. The claimant respondents have also stated that the present action is the continuation of the suit commenced at pure judicial divisions of the court. However, the record of proceeding in this case and the originating process commencing this suit were filed on the 17th day of November 2020, filed at the registry of the court in Calabar Judicial Division, and the action was assigned suit number NICN/43/2020. This has shown beyond any doubt that the assertion of the claimant's respondent as contained in paragraphs 9, 10, and 11 of the counter affidavit did not represent the correct position of this action. The present action was commenced on 13th day The action was not transferred from Uyo Judicial Division, rather, it is a suit that was filed in this division of the court and was accordingly given number in accordance with the numbering of the cases of this judicial division. Having shown that this court has not previously dealt with the issue of abuse of court processes, the present action was never commenced at Uyo Judicial Division of the court. I shall proceed to consider the main issue calling for resolution by the preliminary objection, which is whether the present action constitutes an abuse of process of court. For having been filed during the pendency of suit numbers NICN/Y/41/2018 and that of NICN/UY/06/2019, Anidion Echo versus Mobile Producing Unlimited. Happily, there are numerous uncountable decisions rendered by courts on the concept of abuse of court process. In the case of APM versus ANEC reported in 2023, 9 Nigerian Fluid Report, part 1890, page 41, page 419, the term abuse of court process, abuse of process or court is a term generally applied to a proceeding which is wanting in bona fide and is frivolous, vexatious, or oppressive. Abuse of process can only mean the abuse of legal procedure or the improper use or misuse of the legal processes. The court, under the inherent powers, has the duty to ensure that the machinery of justice is duly lubricated and that it is not abused. See Arugo versus Oyelero. See also Salaki versus Kotowe. The abuse of court process has also been described as the improper use of judicial process by a party in litigation. It may occur in various ways, such as instituting multiplicity of action on same subject matter against the same opponent, or same issue, or multiplicity of action on the same matter between the same parties. It also occurs by instituting multiplicity of action, though on different grounds. A litigant has no right to pursue two processes which will have the same effect in two courts at the same time, with a view to obtaining victory in one of the processes or in both litigation. It is not a game of chess where players outsmart themselves by dexterity of purpose and traps. On the contrary, litigation is a contest by judicial process where the parties place on the On the contrary, litigation is contest by judicial process where the parties place on the table of the justice the different position clearly, plainly, and without tricks. Sorry, Council. My other device I'm using has issues, so I had to discontinue from there.
Very well, my lord, no problem.
As pointed earlier, abuse of process of court may manifest in variety of forms, and the circumstances which will give rise to abuse of court processes include where a party has adopted the system of foreign shopping in the enforcement of a conceived right. It is also an abuse of court process where two actions are commenced. The second, asking for relief, which may have been submitted in the first. The second action is prima facie vexatious as an abuse of court process. The claims or reliefs may be worded differently, but it amount to an abuse of process, where the substance or the end result of the two or more action is the same, whereby the grant of one relief or the claim in favor of the claimant, the aim of the claimant would have been achieved, it amount to an abuse of court process. See Sheriff versus PDP. The exercise of a party's right to sue is not per se an abuse of process of court. What amount an abuse of process lies in the multiplicity and manner of the exercise of that right. See Pashakim Food Nigeria Limited versus Shosanya. Multiplicity of court processes on the same subject matter before one or more courts of competent jurisdiction and between the same parties is what the court have described as improper use of judicial process to irritation, annoyance, and harassment of the other party, and therefore described as an abuse of process. The instant case is a very clear one of abuse of court process by the claimant's respondent, which deserve condemnation by the court. See Ikine versus Ijofo. See also Commissioner of Education, Imo State versus Amadi. I agree with the counsel for the defendant applicant that this action represents a very clear case of abuse of court process by the claimant respondent, and it is condemnable by the court. This is clear multiplicity of action, as there is pending before this court suit number NICN-UY-41/2018, Godwin Indem and 41 others versus Mobile Producing Unlimited, suit number NICN-UY-06/2019, Anidion Echo and 77 others versus Mobile Producing Nigeria Unlimited, and the suit number NICN-UY-13/2019, Lawrence Wakama and 90 others versus Mobile Producing Unlimited. It is to be noted that the present suit was instituted in year 2020, while the pending suit before the court were instituted at Uyo Division in 2018 and 2019, respectively. These suits were commenced in Uyo Judicial Division, but they were transferred to this division where they are currently pending. Despite the pendency of these cases, the claimant decided to close its eyes and throw caution to the wind and went ahead and filed this current action before this court, where the cases transferred before the division were pending, already pending. This amount to a clear case of abuse of court processes meant to irritate, harass the defendant applicant, which the law prohibits. I have thoroughly examined the originating processes in the cases already pending, which are why this application was brought in, and the originating process is commencing the current suit. and it is clear to me that the subject matter of dispute in the case are same as well as the parties. I have also compared the names of parties in all the suits relevant to the application and found that the status of the claimant as contained in Exhibit MPN4 were correct. This means that the parties in the cases pending before the court and in the present case are the same. And having different or multiple cases pending, that clearly goes to establish that the latter case, which is the present case, constitute an abuse of process of court and is liable to be having instituted an action before this court with the same parties, subject matter and issues, and despite the pendency of those suits, the claimants coming to institute an action before this court clearly shows that the present action is vexatious and oppressive, is a vexatious and oppressive action. I'm also of the view that the action was instituted deliberately to circumvent the course of justice and to bring the judicial process into ridicule and disrepute and contempt. It is clear act or course of conduct that is seen designed to introduce anarchy into the judicial system, which must not be allowed and must be dealt with appropriately. See the case of Ikene versus AG Doro. See also Globe Motors Holding versus Honda Motors. See also Dingyadi and INEC. After reviewing the processes in this case and the processes in the cases transferred to this case from Uyo Division of the Court, I have come to the conclusion that and that is my view, the action of the claimant's respondent to institute this action is a clear demonstration of crass impunity and mischief by the claimants and their counsel, who are fully aware and in the know of the status of the cases transferred from Uyo to this court. And they decided deliberately to file this action. I consider the action to be a deliberate attempt to thwart the course of justice so as to cause confusion. What is baffling in the cases transferred to this case from Uyo Judicial Division, the claimants have filed appeals against decisions of this court that were before the Court of Appeal, Calabar Division. And despite the pendency of the action and the appeals, they decided to continue to oppress the dependents with the present action. Therefore, the conduct of the claimants and their counsel in this matter must be strongly condemned, as it is mischievous, aimed at frustrating and annoying the opponent. On the whole, from the processes before me, after review of the processes before me, I have no choice than to come to the conclusion that this case amount to abuse of court processes for having been filed during the pendency of actions that are already before me on the same subject matter and the same parties. The dependent applicant notice of preliminary objection has merit it succeed and same is granted. It is to be noted that the counsel for the application which was dealt with by this court to which ruling was delivered on the 12th day of May 2022, is based on the judgment of the Supreme Court, which was the source and main source of claimants' course of action in this matter. And the previous cases having been also been based on the Supreme Court judgment, they cannot coexist with the present case. Since the present case is later in time, it has to give way to the already pending cases before this court. In the circumstances, the claimant's respondent action amount to abuse of court processes, and same has to be dismissed, and I hereby dismiss it. Ruling is entered accordingly. I make no order as to court.
We are most grateful, my lord, for a well-considered ruling.
You're welcome.
Yes.
Yes, call the next case. And Tiara? Yes. Yes.
Profound respect, my lord. My name is Adetayo Talabi. My parents for the defendants.
This matter is for ruling. The ruling of the court is ready. I don't know if counsel agreed. This ruling is similar or the same with the ruling just delivered, because all the issue is the same: abuse of court process. The argument and whatever that were canvassed were the same, and my decision also is the same with the one I have just delivered. So if counsel agreed, I will skip reading everything just to pronounce the verdict of the court, and we call it a day. But if you want
we don't have any.
Yes, Mr. Marcus. You said? Okay. Okay. As I said, this matter is for ruling. The ruling of the court is ready. I have reproduced the prayer being sought by the applicant. I have also reproduced the grounds for the objection. I have also given a summary of the facts as contained in the affidavits of the parties. I have also captured argument of the parties in respect of the issue raised. I also captured the reply of the defendant applicant. Then I went to my decision, and in the decision, my decision, I have reviewed the evidence, and I have come to the conclusion that the claimant suit as it is presently constituted amount to abuse of court processes and is liable to be dismissed, and same is hereby dismissed. And I made no order as to cost parties to bear their respective costs. Ruling entered accordingly.
I'm most grateful, my lord, for a well
You
considered
are
ruling.
welcome. Yes, thank you, Council, for joining. We have come to the end of the virtual sitting, so Council can decide to go. Thank you very much.
Thank
The
you very much, my lord.
administration can end the sitting.
My lord, can we apply for the citizen today of the judge, the ruling?
You can apply, but I don't think you will get it today, but you will get it next week because I have some judgment. I have judgment and ruling that I have to deliver on Monday and Tuesday, which
Very well.
I have to prepare this weekend. But you will get it next week.
Very well, my lord. We are most grateful.
You are welcome. Okay, bye.